Gun owners across America just watched the legal landscape shift overnight. A federal appellate ruling demolished gun control frameworks built over 40 years, and 10 seismic changes are live this moment. Change number 10 is mind-blowing. What previously meant a decade behind bars is now your protected constitutional freedom. Subscribe to Firearm Legal Briefing and activate notifications immediately, because missing what I'm revealing could mean the gap between lawful ownership and devastating criminal liability. Change 1. Heightened constitutional protection. Courts just upgraded how they evaluate your firearm freedoms, and overlooking this leaves you vulnerable when enforcement shifts around you. Federal benches now position your Second Amendment alongside speech protection and religious liberty, placing it within the highest tier of constitutional safeguards. This matters profoundly because it flips the burden of proof completely backward. Whenever government at any tier proposes firearm limitations, they confront what attorneys call strict scrutiny, the most demanding legal threshold in constitutional jurisprudence. They must establish 3 independent components, and each must be ironclad. They need compelling governmental interest, meaning the issue must be critical and immediate, not merely well-intentioned policy. Most crucially, they must demonstrate zero alternative approaches that would impose fewer restrictions on your freedoms than their proposal. Government must now justify why stopping you is necessary, and the standards are so rigorous that most limitations simply collapse under examination. Constitutional experts analyzing this decision predict 60 to 70% of existing firearm regulations nationwide will crumble under this test. But this elevated protection only functions when those enforcing regulations face real consequences for rights violations. Change 2. Enforcement. Agent liability officers. Violating your Second Amendment protections now shoulder direct personal financial responsibility. And this is transforming how law enforcement engages armed citizens nationwide. A legal shield called qualified immunity previously protected officers like armor when they trampled constitutional freedoms. That protection has been completely eliminated for Second Amendment infractions. Any enforcement officer at any jurisdiction, city patrol, county deputy, state trooper, ATF agent, or FBI investigator, faces personal accountability when violating your gun freedoms. In Harris County, Texas, a judge mandated 3 officers personally cover $2.4 million after arresting someone for open carry, when Texas statute explicitly permits it. A Broward County, Florida officer confronts federal charges and forfeited a pension valued near $890,000 across his career after seizing legally possessed firearms during a traffic stop without legal grounds. In Maricopa County, Arizona, a deputy received a personal penalty of $156,000 and permanent prohibition from any law enforcement role anywhere in America after retaining someone's concealed firearm for 6 hours without justification. Officers receive warnings in unmistakable terms that violating gun freedoms will obliterate their career and financial future. What action would you take knowing the officer who violated your freedoms would bear the cost personally rather than hide behind their authority? But officers aren't just infringing rights during arrests. Change 3. Firearm seizure eliminated. Confiscating someone's weapons without complete criminal justice procedures has been declared unconstitutional, and individuals who lost firearms through these schemes are recovering them immediately. Red flag petitions, civil asset forfeiture involving weapons, and administrative seizures have all collapsed under the new constitutional benchmark. How these schemes operated was genuinely alarming when examining specifics. An embittered ex-partner navigating divorce, a disapproving neighbor, someone from a workplace dispute. Law enforcement would present that complaint to a magistrate and obtain an emergency protective order or red flag directive. They'd appear at your residence, sometimes before you knew accusations existed. Every weapon you possessed would be seized immediately. Your firearms were simply removed, and recovery required hiring counsel and battling through courts for months or years with no success guarantee. The recent decision establishes requirements with absolute clarity. Firearms cannot be confiscated without placing individuals under formal arrest. The complete procedure demands full due process safeguards, including confronting accusers, cross-examining witnesses under oath, and presenting defensive evidence. Across 21 states with red flag statutes, enforcement confiscated firearms in roughly 15,000 instances last year. In over two-thirds of those situations, no criminal accusations were ever filed. Certain states averaged 14 months returning firearms, and owners spent $8,000 to $12,000 on average in attorney fees fighting to reclaim their own belongings. Enforcement would seize weapons claiming potential connections to criminal matters somewhere, even when owners faced no charges or suspicion whatsoever. Anyone whose firearms were taken through red flag orders or civil forfeiture within 5 years now possesses clear constitutional basis to demand immediate return. Time is constrained, though, because most jurisdictions created 90-day filing windows, so anyone affected must act without delay. But confiscation wasn't government's sole privacy intrusion. Change 4. Registry destruction. Mandate federal government has 90 days to permanently erase every digitized gun owner record they've accumulated, and this represents among the most substantial privacy victories for firearm owners in American history. The ATF invested years constructing an enormous searchable registry tracking ownership, and the magnitude of what they assembled is staggering. When dealers shuttered operations, the ATF gathered all paper transaction documentation. The platform enabled typing any identity and instantly viewing every weapon purchase that individual completed. They could query by firearm category and locate everyone purchasing AR-15 platforms or any particular handgun variant, serial numbers, calibers, purchase timestamps, dealer locations. Everything was indexed and retrievable within seconds. The violation extends deeper still. 6 jurisdictions actively transmitted information directly to federal systems through data-sharing compacts. California, New York, Connecticut, Illinois, Maryland, and New Jersey all forwarded state-level purchase documentation to federal servers, where they were cataloged and accessible to multiple government bureaus. The court imposed a rigid 90-day deadline for the ATF to supply certified confirmation that every digital entry has been permanently destroyed. Independent forensic computer auditors must verify information cannot be restored through any method. The responsible officials, including ATF leadership and senior administrators, could face criminal sanctions, including substantial monetary penalties and incarceration. The FBI's background verification system also received directives to purge records following approval. Official FBI doctrine always maintained they didn't preserve records of approved weapon transactions, but internal reviews proved they retained that information for an average 7 years. What action would you take discovering government had been covertly tracking every firearm you ever acquired? The decision clarifies that private information belonging to law-abiding gun possessors cannot be gathered, archived, digitized, or distributed between government departments without warrants based on probable cause of specific criminal activity. But government wasn't merely maintaining static files. Change 5. Monitoring programs terminated. Federal departments are now forbidden from conducting surveillance on lawful gun possessors without securing warrants, and the tracking initiatives just shut down are absolutely staggering. Government departments invested years monitoring gun owners through digital traces in ways most citizens never imagined were occurring. The NSA operated a program with internal designation GunWatch that automatically identified individuals based on internet queries. Searching phrases like bulk ammunition, AR-15 components, concealed carry statutes, gun show calendars, or FFL transfer protocols placed you on a tracking roster. The Department of Homeland Security ran a separate initiative monitoring firearm acquisitions through the banking system. Expenditures exceeding $1,000 on weapons or ammunition within any 30-day period automatically flagged your identity for analyst examination. The ATF managed a program labeled Time to Crime, ostensibly tracking duration guns took moving from dealer stock to criminal usage. They observed private transactions between individuals by monitoring online classifieds, Facebook marketplace listings, gun forum conversations, and even private communications between people mentioning firearms. Every single one of these initiatives has been completely terminated following the court decision. The ruling makes explicit that possessing guns is a fundamental constitutional freedom, and exercising that freedom cannot justify government monitoring. Government cannot surveil everyone attending religious services merely because they're exercising First Amendment religious liberty. Identical safeguards now extend to all Second Amendment conduct. Cellular location information related to gun retailer visits is protected. Payment card purchase history for firearms and ammunition is protected. Any government department wanting access to digital information connected to weapons must now secure a warrant based on probable cause of actual criminal behavior. Over 50,000 gun owners were being actively tracked through these initiatives without awareness it was occurring. Early compensation settlements are averaging around $40,000 per individual, with some situations reaching $75,000 or higher, depending on monitoring scope and duration. But surveillance wasn't the sole barrier government established. Change 6. Licensing procedure reform. Concealed carry licenses must now be granted faster, simpler, and more affordably regardless of your residential state, with 3 mandatory standards every jurisdiction must follow. Processing must be finalized within 30 days maximum from submission. Total application charges are capped at $50, including all related expenses. Jurisdictions like New York were consuming 8 to 12 months processing individual applications, and that timeline began after completing training, submitting documentation, and remitting all charges. California demanded $300 or more when combining application charges, fingerprinting costs, background verification fees, and processing expenses. New York currently holds 47,000 permit applications pending beyond 30 days. Hawaii had granted only 226 total concealed carry licenses in the entire jurisdiction before this ruling. They've been compelled to approve over 3,000 applications in the past month alone, with another 8,000 pending applications that must be processed within the 30-day window. What would you do with a carry license you've been awaiting months or years to receive? Any permit application pending beyond 30 days is automatically approved by federal statute right now. Send a certified correspondence to your licensing authority, demanding immediate issuance and specifically reference the federal court decision. Anyone previously rejected for failing to demonstrate proper cause or sufficient reason can file new applications, and the prior rejection cannot be held against them. This is generating the largest expansion of concealed carry freedoms in United States history, representing millions of newly armed citizens lawfully exercising constitutional protections. But licenses mean nothing without ammunition availability. Change 7. Ammunition purchase freedom. Ammunition acquisitions are now treated identically to any other lawful merchandise, with jurisdictions prohibited from imposing special limitations that don't apply to other consumer products. California mandated background verifications for every ammunition acquisition. New York prohibited all internet ammunition transactions and blocked shipping ammunition into the jurisdiction. Connecticut imposed caps on ammunition quantity that could be acquired at once. Illinois demanded ammunition buyer identification credentials that took months to secure and cost $10 annually to maintain. The court declared what should have been apparent from the beginning: restricting ammunition while claiming to safeguard gun freedoms is equivalent to protecting free expression, while prohibiting paper and ink so nothing can be written. The Second Amendment safeguards the freedom to keep and bear arms, and the phrase "arms" necessarily encompasses ammunition by fundamental reasoning. California alone performed over 4 million ammunition background verifications last year. Many rejections resulted from clerical mistakes like mismatched middle initials, outdated addresses still in databases, or slightly different name spellings. All those limitations are now unconstitutional. Ammunition vendors can sell over-the-counter without special documentation, background verifications, or registration mandates. Ammunition can be acquired from any supplier offering the best value without worrying about jurisdictional boundaries. Stocking up during promotions carries no legal worries. Internet vendors report transactions increased 340% in jurisdictions that previously prohibited shipping. An estimated 2,800 retail outlets that completely stopped selling ammunition due to regulatory burdens and liability concerns are bringing it back into stock. But individual purchasers weren't the only ones confronting government barriers. Change 8. Dealer licensing protections. Licensed firearms merchants finally obtained the same legal safeguards as other legitimate enterprises, ending the ATF's capacity to close gun retailers over minor documentation mistakes. The ATF employed extremely aggressive inspection methods and zero-tolerance enforcement to shutter gun shops over clerical mistakes that would never result in closure for any other enterprise. Recording a purchaser's middle initial incorrectly, the ATF wasn't seeking actual criminal infractions. The new legal benchmark provides clear safeguards. The ATF cannot revoke federal firearms licenses unless there's an actual criminal violation with intentional lawbreaking and criminal purpose. Corrections can be mandated, but licenses cannot be revoked. Anyone currently pursuing a federal firearms license must have their application processed within 60 days. Maximum. 60 days is the absolute ceiling, or licenses are automatically issued. Home-based firearms merchants facing harassment from local municipal and county zoning authorities now have federal safeguards. What would you do if the ATF terminated your enterprise over a documentation mistake? The ATF revoked 122 federal firearms licenses in the past year alone for what they classified as willful infractions, but examining actual situations shows most were really documentation errors and formatting mistakes. Applications for new federal firearms licenses increased 89% in just the past 2 months because individuals are no longer afraid of arbitrary enforcement, destroying their enterprises over nothing. But enterprise protection isn't the only domain where property freedoms matter. Change 9. Search warrant requirement. Federal agents are now forbidden from entering property for firearm inspections without warrants, ending surprise compliance visits completely. ATF agents had a practice of appearing unannounced at gun collectors' residences and homes of federal firearms license holders, and demanding to inspect collections or examine record ledgers. The court decision makes the statute absolutely clear. Federal agents need warrants with specific criminal allegations before searching property. This safeguard applies to everyone: private collectors owning weapons as hobbies, commercial shooting facilities, retail gun outlets. Homes and business properties have identical Fourth Amendment protections, whether weapons are involved or not. The ATF performed over 2,400 warrantless home inspections in the past 3 years. Average compensation amounts being paid are running around $75,000 per situation. with some exceeding $100,000 depending on violation severity and specific circumstances. Federal agents appearing at your entrance without advance notice require a very clear, calm, and firm response. State, "Show me a warrant listing specific criminal allegations, or you cannot search my property." But absolute firmness about asserting freedoms is essential. But property freedoms provide limited help without travel liberty. Change 10. Interstate Transportation Protection. Traveling across jurisdictional boundaries with firearms no longer carries arrest risk in restrictive jurisdictions, affecting more gun owners daily than any other modification. This is what previously carried 10-year mandatory minimum federal prison sentences. It's now completely lawful and constitutionally protected. Gun owners were terrified for years of driving through jurisdictions like New York, New Jersey, Maryland, Massachusetts, Connecticut, California, or Illinois, even just passing through. A man traveling from Pennsylvania to a Vermont shooting competition got stopped in New Jersey for minor speeding violations. Enforcement searched his vehicle and found competition firearms locked in hard containers in his trunk, completely unloaded, ammunition in separate containers. New Jersey arrested him for unlawful firearm possession. He spent over $63,000 in attorney fees, fighting the situation for 3 years before accusations were finally dismissed. A woman driving from Texas to Maine for holiday family gatherings got pulled over for a broken tail lamp in Maryland. She spent 18 months fighting accusations and nearly lost her employment from missing so much work for court appearances. The new federal safeguard provides absolute clarity and complete coverage. If firearms are lawful in the jurisdiction where trips start and lawful in jurisdictions where trips end, federal statute provides protection during the entire journey through every jurisdiction in between. Stops for fuel are permitted. Stops for restaurant meals are permitted. As long as firearms remain properly secured in vehicles and continuous transit from point A to point B continues, arrests and prosecutions cannot occur. New Jersey alone arrested over 800 individuals in the past 5 years for possessing firearms while traveling through the jurisdiction. Thousands more situations across other restrictive jurisdictions are being dismissed. Enforcement stops while traveling with firearms require a simple, direct, and completely protective phrase. State, "I am traveling under federal interstate protection with a lawfully possessed firearm secured for transport." This transforms everything for gun owners traveling for employment, vacations, hunting expeditions, shooting competitions, or family gatherings in other jurisdictions. The fear of accidentally committing felonies just by driving through the wrong jurisdiction with legally possessed weapons is completely finished. Conclusion: these 10 changes are active right now, and they only safeguard you if you know they exist and actually utilize them. If you found this information valuable, smash that like button for wins of thought and turn on notifications so you don't miss critical updates that could save you from arrest or help you recover confiscated property. Share this video with every gun owner you know, because this information could prevent someone from facing felony accusations or losing thousands in attorney fees. Drop a comment below telling me which change shocked you the most and whether any of these modifications have already affected you personally.